All right.
Kathy Nestor, Michael Burt, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of victim representative Ms. Erica Kirk. Good morning. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices. All right, is it the audio working?
Sorry, Judge, the WebEx audio is not working.
All right, well, let's just take a brief moment.
Sorry, I'm muted. It's very sad for me. Good morning, everyone. Welcome to Uncivil Law. Hope you're having a great day.
If you have any...
The judge just gave a very good idea about, using privacy shields to help block what's on the monitor. If you get those things that you can get at basically any store that make it so that if you're not looking directly on it, the screen appears black, that would go a long way towards not having people see what's on your screen. What a deep thought. Deep you can get it for like $20 at Best Buy. So maybe buy those. That'd be really helpful. Today I'm expecting, you know what I just figured out actually? I figured out why this woman defense lawyer irritates me so much. Because she acts like chat. That's why she frustrates me so much. She's heard words like Constitution and due process and hearsay. And she thinks that she understands what these words mean. And she thinks that if she merely says the words, it means what she wants it to mean. I've heard of this thing called due process. Therefore, something, I win. No chat / attorney for the defense. That's not how it works. It's a little bit more specific than that. There's a reason we go to school for 3 years. And then we learn on top of that. It's because these mere words that you've heard in your Solve-Sit lecture do not mean what you think it means. Words like due process incorporate several hundred years of history. It means it has a lot more nuance than the two words would suggest. Because the words have been understood and interpreted and reinterpreted and reinterpreted. It's a little complicated.
Something to look at. I see. All right. All right, let's go ahead and continue.
Thank you for the gift memberships. That's 50 gift memberships.
Let me repeat it just because.
From Candy Marie, that's very generous indeed.
All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protection.
That would be a really good idea.
And care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom.
Yeah, some screen protectors would be a really good idea. Really basic idea.
Photographer, and I will invite you to come forward.
Tell your friends about this stream.
All right. The purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television.
Are they required to wear the checkered
Have you
shirts?
reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities?
Does
today?
Utah have the death penalty? Very much
Do you require
yes.
additional time
They've
to
got
review the
firing
order or
squads.
To adjust equipment to ensure compliance.
No.
Do you anticipate any difficulty complying with the order or today?
They
or
will
with the
shoot a
court's
rifle bullet
instructions?
into your heart,
All right.
which has the benefit
Well,
of being
thank you.
very
Appreciate your
effective.
cooperation today.
Court volume is low. That's a fair point. Let's fix that.
As we begin this morning, the court wishes to acknowledge the importance of the
There we go.
safety, dignity,
There,
and
that's
well-being
better.
of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled.
Hey, I'm
Consistent
here to
with the court's
I'm here to
standing
make the volume
decorum
nice.
order,
I want you to be able
all
to hear
spectators
things.
shall remain quiet.
So when you're
civil,
like,
and
oh, the court
orderly
volume's low,
during
I'm
all
like, oh,
times.
yes, it is. I can fix that.
Spectators shall not
Yoink,
engage
no
in conduct
problem.
that is distracting, disruptive,
Excellent.
provocative, disrespectful, uncivil, or threatening
Uncivil,
in any manner.
that's me.
Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions
I make
during today's
gestures.
hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a
Oh my
courtroom
God, Tony, you
environment that
ran
is
out of
safe,
coffee?
respectful, orderly, and faithful
That's
to the
horrible.
rights and dignity of every person involved.
You got to break out the emergency
Turning now to
supplies, the
counsel.
instant coffee or whatever you've
Before
got,
we
man. You
begin,
got to
I
make
wish to
you got to
acknowledge
make
the
do.
professionalism,
That's
civility,
horrible.
and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the
I
court
took a
that you
caffeine
two
pill this
approach
morning.
This matter with
I'm not
seriousness,
messing around.
preparation, and a deep commitment to your respective
Because yesterday was
responsibilities.
draining
The court
of
appreciates the care
boredom.
which you have
So it's like, I'm
taken
just gonna
in advocating
skip
for your positions
the
and
coffee and go
respectful manner in which
directly
you
to
have done
caffeine
so.
pill and save myself
Thank
the
you.
time.
Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right, and just as a reminder, the microphones.
Oh,
at
that's what he
council
means
table
by
are turned
benefit of the
off to
record.
prevent
Oh,
the
okay.
inadvertent
He
capture
just
of any
means, is there
communication.
something
So,
additionally
if
you
you'd
want
like
to put on the
come forward,
record?
Thank you.
Oh,
And
okay.
turning to Mr. McBride.
That's what he means by
Honor.
benefit of the record.
Before
Okay,
this
we
hearing,
finally
the
got that
defense moved
fixed.
to-
Oh, great.
Find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively
No, I
briefed
appreciate the
and
ritual.
argued.
I understand that.
The court denied the
I'm not
defense
looking down
motion
on
to
you.
exclude the use of reliable hearsay at the preliminary
Get your
hearing.
coffee into you
That
any
ruling
way
is
you want,
docket
man.
Number 631.
Order some Starbucks.
In addition,
Or
defense
some
counsel filed
Instacart
a
and get some
standing
coffee
objection on
delivered to you.
July
I don't know,
3rd.
man. You
That's
gotta fix
docket
your problem.
678. The standing objection
You don't have
reasserted the
emergency
arguments
Insta
made in
coffee
the defendant's
for
previous
something for
motion.
like when you really get desperate? You got to have
Defendant
backup
continues to
supplies,
make these
man.
same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing.
I'm sure
on
you
the
do,
point
but it's in the Constitution
preserving
of
the
Utah, so
objection that
fuck
has been
off.
done. Defense counsel has filed
Can we
their
please
motion.
listen to the
They filed their
proceedings?
standing objection.
No.
Throughout
This
the
is a
proceeding, they
commentary
continue to
channel.
make
Also,
objections.
you're not missing
At this
anything.
point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction to
I make it
continue objections
unwatchable?
on this ground are
Okay.
unnecessary. Of course,
Well,
if it relates to some other
noted.
ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause
Yeah,
undue
no, we're
delay.
still objecting
Thank you, Mr.
to the
McBride.
hearsay,
To defense.
even though the Constitution of Utah specifically allows for it in this situation. So we're still objecting to it, even though
morning, Your Honor. Michael
literally
Byrd for Mr.
it's in the
Robinson.
Constitution.
We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the
We're going to hear more of
constitutional
this.
rights of Mr.
We're going to hear this
Robinson,
objection over and
the court
over
will not
again.
prevent that, nor stand in its way. This court is not
Please
is
stand-
acting
please
in the
stand in
role
the
of a
defense's way.
magistrate, and will allow the parties to move forward
Please stand in the defense's
as
way.
necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand.
Do the
to
objections
resume
during a
direct
preliminary hearing go to
examination.
appeal?
And Agent
No.
Hull, you are still under oath.
No, they don't. They would be
Mr.
part
Sturgeon?
of the appeal from the eventual
And
conviction.
before we begin, is there a way to dim these lights just a tad like we did yesterday?
So, no.
Perfect. Thank you. All right. As of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, your witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit?
Yes.
And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation
Yes. The compilation video that we couldn't do yesterday. Now we're going to do it without all the additional edits.
We can't hear the witness.
And that's what I hear. So let's go ahead and stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
check.
All right, I believe that.
Thank you.
Mr. Sturgill, if you wouldn't mind restarting.
I can do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. I don't know if that will help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Okay. Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
Okay. And in its entirety.
Yes.
And he actually, and then you collected an 1102 statement from him.
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit?
Yeah, I mean, if you
12.1
want to
in his
watch the
statement?
trial
He
without
did, yes.
commentary, there are very specific channels to go watch that. For example,
I'm going to put on
Court
your monitor
TV,
State's Exhibit
right? It's like,
12.3.
I want to watch the trial. I don't
And
want commentary.
asked that you
Why are
scroll
you
down
here?
towards the very bottom. And
For
I
that
would ask
matter,
you
why
read
are you
from
at
the
any
statement,
influencer's channel?
Specifically what Mr. Olson said.
That seems
about
like
State's Exhibit
that seems
12.1.
counter-effective.
And I want to narrow your focus, so I'm going to draw your attention about three
You know,
quarters down the page.
like,
There's a
yeah.
sentence that begins on the left margin, I have reviewed. Do you see that?
I do, yes.
Okay, would you please read that sentence?
Does the
have
state
reviewed
have
State's
enough to go
Exhibit
forward?
12.1.
Yes.
The recordings are
Obviously,
true and accurate,
yes.
including timestamps.
The
dates,
result
and
of this
camera
hearing
labels.
was a foregone
The
conclusion.
only changes are
The reason we're doing this hearing remains
highlights,
somewhat
which were not part of the
questionable.
original recording.
I don't know why we're doing it.
Would you like me to-
I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance?
There's got to be a reason. What that reason is
you reviewed
unclear.
the raw footage yourself. Is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
And
Your Honor, we just object to the publication of this for all the reasons we argued yesterday.
Shut up.
We think this video is going to play a big role in
Shut your
the
mouth.
trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
thank you. And Mr. Surgeon, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, to be published in the courtroom and captured by the media. So, Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so our position
it's
is
like-
that it should be published here in the court.
Yeah, it's like I'm not an expert when it comes to 30-06 ballistics, but like we can, using what limited knowledge I have, it's like I can try to put things together. I'm more of a pistol shooter. I've never really shot rifle. I'm a pistol guy. I used to do pistol competitions. It's been a hot minute. I don't have skills anymore because it's been too long, but I used to be half decent. Anyways, using what limited knowledge I have, like you have a bigger bullet moving at a faster speed. And so you have a lot more energy, obviously, going into the system. Now, when you go into the neck, depending on what part of the neck you're hitting, right, there isn't as much mass there to react to, for example, as a center shot. So if you're shooting someone in core mass, obviously there is a lot more stuff there for the bullet to interact with. So you would expect more damage just logically from a core shot, just because there's more stuff to hit and more stuff for the bullet energy to disperse into, right? If you're hitting someone in the neck, some of the energy is not going to be absorbed because there's nothing to absorb it. So, and also like the amount of mass, like from back to front, is less than center mass, right? Depending on where exactly you hit in the neck, there's less distance to travel through. So, you know, the energy of the bullet isn't going to all dump into the system, right? Because a lot of it's just going to pass through, not all of it. So without really being an expert in ballistics, you know, what I would expect to see is some significant damage, including some hydroshock damage from the bullet hitting liquid and causing the energy to ripple through the liquid, which doesn't compress. So it travels more effectively, causing a lot more peripheral damage, but not necessarily like the same amount of energy that you would see in a center mass hit. I'm sure when we get to the trial, we'll hear much more information from actual experts of ballistics, both for and against. But I don't know. Seems plausible, but I'm not an expert.
Well, first of all, if I could take one step back, let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September 10th, 2025 into the morning of the 11th, 2025.
And if you wouldn't mind just describing in a bit more detail what this compilation includes.
If the bullet doesn't escape the body, then all the energy of the bullet will necessarily be absorbed by the body, because that energy has to go somewhere,
arriving and leaving in a vehicle.
So if you hit smaller mass, but all the energy was absorbed, then you'd expect to be much more devastating.
His movements
but because there's less mass to stop the bullet is more likely to pass through. Right, because there's less mass to stop it, because you don't have as much of a stop. So therefore, you'd expect it to be more likely the bullet to pass through
of the
rather than
alleged
be
shooting.
contained within the system.
Okay. I just wanted to clarify that. Ms. Nestor, given that additional information and anything further from defense.
Your Honor, Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address.
The state's arguing against the first law of thermodynamics? No, they're not.
Yes, Mr. Burt, if you wouldn't mind coming forward.
They're absolutely not. The energy.
I wanted to clarify one argument that was made.
Yeah,
by
the energy is simply not all being dispersed into the body. It's not like the energy is disappearing. It's just that the energy is not being deposited into the body because there's not enough mass to stop the bullets.
This rule applies.
So the bullet is not exiting the body, or apologize, it is exiting the body. As a consequence, the energy of the bullet is not all being dumped into the body. A significant amount of energy is still going with the bullet, traveling outside the back.
A fair trial.
So all the energy is not being leaked into the body. A lot of the energy is not being dumped into the body. So that's not arguing against thermodynamics. We're not saying the energy disappeared. We're saying the energy didn't dump into the body.
An evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether
and it's also possible
preliminary
the
hearing
bullet
should be
deflected.
sealed is
And some of the energy was absorbed by
one
something
of
else. That's
a,
also
quote,
possible.
realistic likelihood of
Because,
prejudice.
yeah, because it appeared
We
that
rely on
that Charlie
evidentiary
Kirk was
showing
wearing
we've
some
made
kind of
in
body
connection with
armor,
our motion to
right?
exclude cameras,
I mean, we watched
there
that
is a
bullet shot
realistic
many,
likelihood
many
of
times
prejudice in this way.
to a disturbing amount of detail, and it seems likely that the bullet initially hit him on body armor, which absorbed a lot of the energy.
Closing this hearing to
Then
the cameras.
it
And the court knows that
bounced
one
off the body
feature
armor and hit him in
of
the
media
neck
coverage
and
has been
continued
a
to pass
very
through the system.
pro-prosecution bias
So
of every
some of the
story that
energy
has
dispersed
been
presumably
published on this
into the
account.
body armor.
The court also
And we
notes
might
from
see
that
bruising
coverage
on his
that-
torso as a
that,
result.
Information is
That
being
too.
widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors.
Did the bullet go
who will be
through?
part of
That's
our
my
jury
understanding,
pool.
yes.
And we've also submitted to the
understanding is
court
that the
a
bullet
public opinion survey,
passed
which
through his
shows
neck.
that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit
He wasn't wearing body
should
armor?
not be allowed
It seemed like he
because
was.
There is a
There seemed to
realistic
be some
likelihood
mass
of
under there,
prejudice
but
to
maybe he
Mr.
wasn't. I don't know.
Robinson's right to a fair trial.
Again,
So
we'll
under that
have a lot more of
standard,
those
under the
details
rule,
during the trial,
court
I'm
ought to
sure.
deny publication.
There will be much
Thank you, Mr.
discussion of the
Thank you.
ballistics during the
Any
trial.
final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree.
Why would it matter
about
if he was wearing
what
body
said
armor?
about the rule?
Because
What
the
we were
bullet
talking about
seemed to hit the
yesterday was
body
something
armor.
different. That is the
That's why.
portion of the rule that classifies.
Based on what we observed, it appeared
records that are in the court file.
that
you
the
know.
bullet might have hit
It's
his
not
body
the
armor.
same as what happens in a public hearing. And Mr. Burt
Deflected
referenced
off,
the portion of the rule
hit
that
him in the
essentially
neck, and then passed through.
just tracks the constitutional standard, which of course, controls.
So,
here
if he was
as to
wearing
whether,
body armor,
in this public
then
proceeding, it can be closed.
some
in any
of the
way,
energy
and
of the bullet
non-publication of
was dumped
exhibits
into
is
the
a form
body
of
armor
closure.
and his
So I don't
torso.
necessarily disagree. I would just
So less of the
underscore
energy of the bullet was
a lot of
therefore
what Mr.
available
Burt just said has
to make
been
damage
briefed
to
ad
his
nauseam
neck.
At this point,
Therefore, the
position
injury
that
to his neck would be
publicity
less
is incompatible
than if the bullet hit his
with,
neck directly
with a
because there
fair
was less
trial.
energy.
The Algier
That's
case
why it
you
matters.
mentioned,
The energy has to go somewhere.
I litigated that case. It involved a confession.
So the body
that
armor would
the
be a
court
reasonable
found
explanation of where
public
some of the energy went.
because you have so many
That's why
other
it matters.
tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty
Again,
and difficult
during
to
the trial,
overcome. And
there
it
will
is
be
never
much
satisfied,
explanation
as we
of this.
explained,
I assure
by
you.
just generalized
We won't
assertions
get into that
there's a
during
lot
this
of
hearing,
publicity out
I
there.
would
It's gotta be
imagine.
something really specific.
But during the
and
trial
we
itself,
just
there will
haven't
be
made that
much
showing.
discussion
And I certainly don't
of
think
if
that
he
a
had
video
body armor, what
that
kind of
apparently
body
just
armor,
shows
exactly
the
what
defendant
brand,
walking
what
around
damage
the
occurred to
campus
it.
qualifies.
That we will go into excruciating detail about all these
Anything
things.
further?
I assure you by the end of this trial. Your questions on this matter will be satisfied. I have very little
I'd like
doubt.
to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that.
Oh, yeah, no, it has
There is
nothing to
video,
do with the
however,
sentence.
You've heard testimony related
Yeah,
to
no.
this.
He shot the
where,
bullet. If he died
the
as a result of the
shooter
bullet,
goes to the top of the
then
LOC
that's
building,
pretty much the end of that game
goes
for
out to
him.
the edge of
It
the
has
building,
nothing to do
low
with his
calls,
liability.
and then leaves
And it has nothing to
after
do
what
really
we
with his
assume is
sentence.
the shot being fired.
It's
That's
just
as close as it
it's just a
gets. I
question
don't know
of
if that makes
fact
a difference, Judge.
about
I just wanted
exactly
to
what
make it
happened
clear, and I want to be
from a
crystal clear with Your Honor.
factual matter.
Thank you. I
But
appreciate that.
The technical
Clarification,
details about exactly
as
what happened
is guiding
have no
for this
impact
court.
on the trial. They just
In
have
this ruling.
impact in sort of
I turn to
satisfying our curiosity.
Utah. Well, let me pull this up.
If there's a trial, there would have to be. I don't think the state's going to offer him a
Rule
deal.
4-202.
And it's why would he plead guilty to a death penalty?
I go down
And
to,
even if he did, the state would still do sentencing anyway. And they're still going to bring
First, it
everything
says
into the
statement of the
sentencing
rule.
hearing. So hypothetically, it's possible. it's hypothetically possible the defense will
court records are public
plead
unless
guilty
otherwise classified
and dump their
by
case
this
into
rule.
sentencing
2, public court
to save their
records,
ammunition,
public court records
as it were.
include but are
So
not
that's a non-zero
limited to-
possibility.
And I'm going to go
So
down
there
to
is a non-zero
2J,
possibility that the
exhibits
defendant will
that the
plead
judge may
guilty
regulate or deny access
and
to
dump
ensure
his
the
case into the
integrity of
sentencing hearing.
exhibit, a fair trial,
That could very much
or
happen.
interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld.
Yeah, I think you're slightly
As it relates to
overestimating the
this
probability of it going to
exhibit,
trial.
I believe it's
What I'm
12.4.
describing to you
12.4,
is a realistic
Based off the representation
possibility.
of what is
It
in
has
that,
definitely been done.
the
It's
court
definitely been done
differentiates
in death
this
penalty cases before.
exhibit from the exhibits from
So
yesterday,
it has definitely been
namely
done when like
exhibit,
liability is
7,
basically fried.
Exhibit 8,
That the defense pleads guilty to try to like
and
salvage their
exhibit
credibility,
9,
right? It's like we're
as
not going to
those
fight
are
you
different in
on the issue of
nature.
whether he did it.
and those
We're going to dump
go
everything into the
to,
sentencing hearing.
issues
In the hope
relating
of,
to
saving
Utah
your
Constitution,
ammunition,
Article
not
1,
irritating the
Section
jury,
28, as it
conceding the
relates
obvious to
the
gain some
Declaration of
credibility. It
Rights
has
of
definitely
Crime
been known to
Victims.
happen. It is not unheard of
And the court also
in death
recognizes
penalty
Utah
cases.
Rule of
So
Evidence
the possibility of
1102
him pleading
as
guilty,
that is the foundation that's being
it is a
laid,
realistic,
for the
if
admission
somewhat
of
unlikely,
this
but very
exhibit.
possible
Having
outcome.
taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. And we can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same, attempt that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess?
Yes, on each occasion we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor what you're going to see is a paused or a still image. And I'm going to ask if you recognize what you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run And then if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet.
Let's go ahead and put it on all screens. No, I appreciate it. It is so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry.
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you? Were you able to refresh your memory as far as the time?
I was, yes.
Okay, and what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially,
Yep.
where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right.
Yes. So yesterday, defense asked why the body cam footage ended while he was on the roof. He stated that he thinks the battery went dead. Then later, defense confirmed that the body cam clip was 27 minutes and 35 seconds, began at the hall flags, and ended while he was still on the roof before the crime scene tape was up, and was the only body cam footage from that day. So it's not clear. The way he testified, it said that it ended while he was on the roof, but not clear exactly at what point while he was on the roof from what I can see in the transcripts, at least at some point before the crime scene tape went up. So that's what he said yesterday. All right, back to today's hearing.
What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
Yeah. He does look like he's limping.
And again, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
All right. So right now, if you were to break this picture into quadrants, where would he be?
He would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
Okay. What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes,
So
2025.
we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. And they move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
And what shape is that triangle?
Do you see Mr. Robinson now?
I do, yes. He's
And
just
what
arriving
color?
at the corner of the building.
What shade of
top center
white?
of the image.
Yeah, good times.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
Okay. What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
Okay. And on the screen, where is that vehicle that you're referring to located, if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
And that vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail,
Okay, and do you know who that officer is? Or
Officer Goforth,
Okay, and do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
Okay. On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that, I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information?
Yes, he ran a partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes.
And did he tell you who the owner of that vehicle was?
He did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Okay. Let's return again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as State's Exhibit 12.1, and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And this is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
Great,
And
thanks.
other than do that, do the circles or the highlights, do they do anything with regards to the video itself as far as its accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been
The red
mentioned that we've
circle was
talked
the name
about
of the
is there's
nightclub
some
in John
blurring.
Wick.
Yes.
Coincidence?
Do you know what that-
I think not.
Tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage, and their faces were blurred. Excuse me.
Is anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out?
We do value all of our new members. Thank you for those of you who hit the membership button. It is only 99 cents a month. We are the cheapest that YouTube allows it to
Not to
be.
my knowledge, no.
So hit
the
that
last thing is, I
beautiful
believe,
membership
is there's some
button.
zooming in
Stop
and
being
zooming out
gray.
that's in 12.1 that
Be
has been
green like a
removed,
cool person.
Yes.
12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video,
No,
the accuracy of the video in your mind?
no.
Okay. Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1.
This guy is
are they
much better
helpful
than
in any
Lally.
way,
That is very clear.
What do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the low-C rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
Before. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1.
You missing anything interesting? We've seen video we haven't seen
at least
before.
that part of the video
That showed Mr. Robinson's
seeing
movements
Mr.
during the day.
Robinson and
So that's
tracking,
been
I guess, his
illuminating
steps.
to some degree.
So, yes.
See him in the parking garage, see him climbing the
Judge, at this
steps,
point, I think
see him
in
on the
combination with
rooftop,
yesterday,
see him dropping
the foundation
onto the
that was laid
rooftop,
yesterday,
see him escaping from the
including,
rooftop.
the written statement
So,
from Mr. Olson.
That's been
which has
somewhat
been admitted
illuminating.
into evidence and is, well, it's already been admitted to evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, and we renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4
Well,
words,
I
unless you want to share that.
I
with
can
me.
read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may, let me just read the whole rule for completeness. The court may exclude relevant evidence if its
403?
probative value is substantially
Okay,
outweighed
Rule
by a danger
403.
of one or more of the following: unfair prejudice, confusing the issue,
Yeah.
misleading the jury,
Unduly
undue delay,
repetitious,
wasting
unduly
time,
prejudicial.
or needlessly presenting
Yeah,
cumulative
Rule
evidence.
403.
I'm not looking
Great.
at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video.
I agree with the
and
prosecutor.
Unless you have very, very, very good vision or you've zoomed in on that.
I agree with the
that,
prosecutor. It's not
monitor,
unduly
You
prejudicial.
really can't see what
Or unduly
Agent Hull
repetitive.
has just described. The character of 12.1 is it simply, it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1?
Thank you, John,
Well,
for the $10 super chat. That's very thoughtful.
12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I
suitable.
don't find it's necessary to replay this video, given the representation that it's the exact same video, the difference being enhancements made. And if it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations.
Thank you,
the court
Candy
does not
Marie, for the
find that,
50
the
gift
interest of
memberships.
justice
That is
requires it
very,
being
very
played
thoughtful.
again.
Thank you for being a
But
member for
it is
33
received into evidence
glorious
and will be
months.
reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1.
You
has
get a
been
membership
admitted.
and you
It
get
is
a
received
membership.
into evidence, yes.
Everybody
And
gets
your
a
intent is to
membership.
review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge, or maybe one run request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it. And then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in, how long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right. Thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitors at counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize it's zooming, but in balancing constitutional rights there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Counsel's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
Great, I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the vote. You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I will. All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
So if I could just have one moment. Hold on, Kimberly. I'm not sure where the power button is on this.
Good.
There we go.
All right, counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right, Thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view. And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping, as we go, or when we finish is fine. I just want the record to be complete.
Just the difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so-
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm just trying to create a record of what exactly I'm looking at.
BRB.
Whenever we pause on the court system,
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
So the count on the video is just before 6-minute mark, Judge.
All right.
And just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. So it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. Judges, and we'll play it. Go ahead, Kimberly.
It's playing.
All right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, 8:23, okay.
8:23. That's the count on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hull, you were able to watch that zoomed-in version, is that
Yes, sir.
right? Okay, and was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing. Strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Well, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor.
One moment, Your Honor, if I may have the court's indulgence. Thank you. Do you want to take your...
And I was just going to suggest that. It seems like right now is a good time to take our morning break. It's 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
Okay, friends. Hello once again. Welcome to Uncivil Law. So far this morning, we've got into substantive evidence relating to the case. Yesterday was a lot of procedural setting up that was quite frustrating. But today we've actually gotten some actual evidence relating to the case. Yesterday we established we found a screwdriver and we found some divots in the gravel that suggested someone lying in the prone position, where you might expect their elbows and arms and knees to be, for example. Today, we got some nice footage from surveillance cameras showing the movements of Tyler Robinson on the day in question, from his in the parking lot to his climbing the stairs to his being on the roof to dropping onto another roof, his escape from the roof. So we've gotten our first look at the movements of the day of Tyler Robinson, him being in the place where we believe the shots to have come from, his escape from that place. We also saw him moving with what looked like a limp as he was climbing the stairs, suggesting that he might have had his rifle concealed in his pants. And that's so far what we've got in today. And then, of course, objections as to hearsay and other things that are complete crap. We've also had some interesting discussion so far today with the chat about speculation relating to the exact mechanisms of death, because there's a lot of conflicting information out there, to be honest, which is one of the reasons that I tend to ignore it, because there's a lot of people who have said a lot of things with a lot of confidence, and it's very difficult to determine the truth of these things. But that's why we have a court process wherein people will testify under oath about things, and then we will have a much better picture of the facts as it relates to the exact way he died and details relating thereto. Yeah, I was just checking my phone, dealing with clients, as one does. Yeah, it's not a trial. Yeah, Court TV, it is not a trial, Court TV. That's very unhelpful. It's a preliminary hearing. It is not a trial. You would expect Court TV to be more precise about these things. Aren't they supposed to be the experts? I'm going to go yell at their channel page for a second. Hold on. Where's the live chat? Fix your banner. This is not a trial. You are Court TV. You should know this. Please stop spreading misinformation. information. There is already enough of that in this case. Smiley face. Great. Yeah, in the get off my lawn, yeah, pretty much. Pretty much exactly that. This is not the greatest trial in the world. No, this is just a tribute. Haven't gotten yet to the greatest trial in the world. No, this is just a tribute. Oh, oh. Some people in court TV are now arguing this is a pretrial. So that's the trial. It's just a pretrial. No. This is a preliminary hearing. The rules of evidence are different. It's a material distinction. It's like the rules of evidence are different. The standard is different. What we're trying to establish is different. Yeah. The judge, acting as a magistrate, since he loves to share that distinction, sure, is trying to do something completely different than a trial. Yeah, this is a cover band version. Although the defense lawyer is still just as annoying, so that's nice. Thank you for the 314 of you currently watching. I hope you're having fun. What would you guys like to talk about since we have some time? Is there anything in particular you'd like to talk about? The evidentiary picture in this case is just starting to unfold. We won't get answers to a lot of questions in this hearing because the state just has to make its prima facie case. We are expecting to hear from Tyler's boyfriend via video appearance, I believe, at some point during the hearing. That should be interesting.
We'll go ahead and pick up where we left off. I note that the parties for each side are present in the courtroom, and we're picking up with cross-examination of Agent Hull. Ms. Nestor, your witness.
May it please the court, thank you. Good afternoon, Agent Hall.
Good morning.
You and I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So, when did you leave the SBI?
The State Bureau of Investigation?
Yes.
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically?
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So When you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that, or were you not
It's
involved in
not,
that?
no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building?
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared, an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
The cartridge.
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
Cartridge.
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard it.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter?
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you?
Correct.
Wow, this is really
And
insightful.
were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay, and just a moment, Your Honor.
This is going to go somewhere, I'm sure. This is leading up to something, right?
And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay.
Great. Moving on.
Can we pull up?
So let me get this straight. In the immediate aftermath of the shooting, the police were trying to interview
Hole
people
13?
as potential suspects or
We'll just
witnesses,
show it only to the witness
and they
for
talked
right
to some
now?
people. Wow. Tell me another story. The police were talking to people and asking them questions about stuff and things. Yeah. It's almost like they were investigating, don't you know?
All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
What are you
And
doing?
Do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay.
Okay. You didn't write this report, though. So what are we doing? He didn't write this report. Someone else's
Okay.
report. Sure, that's what it says. Okay,
When
moving
did
on.
you first personally go up to the roof of the Losi building?
Sounds like
Do you
you're asking the
remember
wrong
time of
person
that?
about this.
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there, there was already crime scene tape that had been placed around it?
There was an officer standing security.
All right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, do you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline, is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report. that you prepared? Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
That looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
Yeah.
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation,
Yeah.
over a long period of time, after a lot of reviewing video and investigative time.
Sounds right.
So.
Sounds like what a police officer might do.
September 14th.
Yep.
Tyler Robinson had already turned himself in to the authorities, is that right?
Yes, I believe he turned himself in on September 11th.
So prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
Sure.
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay.
Right. True. Yes, and
you became
therefore,
aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation,
Okay.
or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down.
okay.
All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
The individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that, is that right?
Excuse me. Determine who he was, or determine distinguishing features?
Determine distinguishing features of the video of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the...
Correct.
From the parking garage.
Correct.
But the video on the roof was not distinguishable, fair?
That video as a standalone?
Yes.
Was not, no.
Okay.
I assume these questions are going to go somewhere, which is assuming a lot. But yes, at earlier stages of the investigation, we hadn't yet figured everything out. We didn't do a Michael Proctor and 45 minutes after the investigation started say, we know all the things, because we're a competent police department. We weren't quite sure yet. Even like the next day, we still weren't sure yet. Because, we were still doing investigation and reviewing things. And, we had some ideas about things, but, not necessarily all the ideas. And we hadn't yet put together a full and complete timeline. There were some people that were trying to put together some timelines about what they believed were true. But, there was still some uncertainty at this stage of the process about exactly what happened and when, and in exactly what order. And we didn't know exactly who had done it yet. Like, early in investigation. And then later, we were a little bit more confident because there was more time and we reviewed more stuff and we had more confidence. And so we were able to put together a better timeline, but still not necessarily the final view, even 3 days later. But we had a better idea. That's how investigations go. We didn't know anything. And then we started looking, and then we knew more things. And then we looked harder. And then we knew even more things. Yeah. Great. Moving on.
And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few
You mean
seconds
witnesses?
before the shooting of someone on the roof?
Sure.
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video.
And ultimately, some screenshots were taken out of that video, is that right? By you?
Not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you
Great.
see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay.
Yeah. Okay. Moving on.
There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As he crossed the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone.
Right.
I think it took longer for him to crawl into position.
Okay.
And then establish a position, and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay, thank you.
Yeah, we could go time it. Why are you asking me?
All right.
Also, is 15 to 30 seconds long enough? You bet your ass. Yeah, geez, 15 to 30 seconds it took to lie prone, establish a shot, and fire. Is that enough time? Yep. Yep. I'll do it. Yep, sounds good. That sounds good. Yep, moving on.
I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? behind Mr.
Are
Kirk.
you referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay, and can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Low-C building. Is that fair?
I can't answer that question.
Fair enough.
Yeah, sure.
Fair enough. He's not God. I appreciate that answer.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not.
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
Okay.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing?
What do you think that this camera
Do you remember
reveals?
that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind.
Okay, so far in this question and answer period, I've learned that this investigator seems to be pretty competent at his job. He doesn't make assumptions. And although he is the lead investigator, other people are doing investigation. And he doesn't know everything that everyone knows instantly the moment they know that, because that would be impossible. You know, at some point later, it sounds like on the 14th, he cobbled together everyone's notes in order to make a report. But in the immediacy of it, it's like, you know, I don't necessarily know everything because I'm not God. You know, I had my attention to the overall scene management as one does, and I had some knowledge of things I observed myself. But no, I don't know everything because I'm not God. And I was doing investigation as one does, as they investigate. And as I learned things, it helped inform me, and then I learned more things, and it helped inform me more. What are we doing over here? I'm confused. Moving on.
Behind Mr. Kirk while he was talking, looking out at the audience when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you.
Great. And what?
All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I was
analyzed?
not, no.
Okay, thank you.
Why would he be?
All right, now I want to shift to the autopsy for just a moment. You
Okay.
were not present at the autopsy, is that right?
I was not.
Okay.
Whoa.
So anything...
You mean unlike the Karen Reed case, the lead investigator wasn't present at the autopsy whispering into the ME's ear? You mean unlike Mr. Proctor, he wasn't at the autopsy observing? Whoa! You mean the medical examiner might have actually been independent? Amazing. Great. Moving on.
You know about the autopsy was not from personal observation.
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the
Probably.
autopsy?
I did, yes.
Yeah.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
Would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay, so you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Probably.
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay.
Good.
You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of
have
anything
chain-
that was
they have chain of custody
transferred
technology?
after Mr. Kirk's autopsy?
They have chain of
I'm
custody
aware that there were
technology?
items transferred for evidence, yes.
What
Whoa!
items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my
Do you
head.
know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on
Sure.
the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble, yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole... Sorry, just a moment.
Yeah. They might have actually used evidence bags too. And used a log. I guess the technology's better in Utah than Massachusetts.
Whole 48. This is Miss Noble's interview. Do you have it?
Erica Kirk was in fact in the courtroom at the start of the hearing. The judge made a note of it.
All right. Do you remember that?
She was
Looking
there
at that
yesterday
interview,
as
does that
well.
refresh your recollection?
So
I
Erica
remember
Kirk
reading the report at some
is
point,
there.
yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that ring camera, did you?
What?
I did not.
And did they also tell you there were 3 other people in the car?
Who?
Yes, I believe they thought that was the case.
Okay. I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Yep.
You received tips of death threats that Mr. Kirk had received before, the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was a
you.
confusing question.
Yes, it
As you
was.
were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Yeah.
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
Right.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
Yeah.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I don't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew.
What does this have to do with the price of tea in China? Does anyone have any ideas? Yes, he turned himself in. Yes, he drove to the police station. Yes, he walked in voluntarily. Therefore, what? You know? Yeah. It's like, where's my triangle, right? Where's my triangle or my 3 dots? You know, my 3 dots in a triangle, you know? Therefore, what? It doesn't go anywhere. Okay. Tell me more.
knew his name connected with this case?
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
Okay. Great.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Okay. I'm sure it matters somehow. I don't know how it matters. This sounds like a pretty competent
Thank you,
police
Agent
investigation
Hall.
to me.
Consider the witness, Your Honor.
Thank you.
Wow. Just round of applause on that cross-examination. Round of applause. Really blew the lid off that with that cross-examination. Man, I'm just feeling all the reasonable doubts, man. I'm feeling so many reasonable doubts right now. I mean, this police officer doesn't know everything instantly, and he doesn't necessarily do everything himself personally. And he relies on other people to do things who are doing things. And he got information from those things and followed up on some of those leads personally, and other things other people did. And then he cobbled it all together in a report 3 days later. My mind is just blown. Wow. Amazing. Great.
By the state.
Do you really have to
Go back
redirect
a few
this?
things that Ms. Nestor asked you
I mean,
about. First of
I mean,
all,
why
the
bother?
unfired bullet that you referred to. Is your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. Mm-hmm. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they?
I believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that round was from an officer clearing his weapon, what exactly do you mean by that?
What do you mean? What do I mean?
Our standard practice in our department is to carry a rifle cruiser ready, which we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And
Makes sense.
Is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars, so I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the
No,
Losi
this is the
building and ran
government.
across, I believe to the northeast corner, when did you first notice
This is
in that
the
video
government
something
attempting to
in his
rehabilitate
hand?
his witness, which is really not
The first time you
necessary.
can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail?
It appears to be black, and it appears to be longer.
Okay, anything else?
That's what
about
she
that
said.
item?
Hey, yo.
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video, is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner
Sure.
in that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that
Correct.
fair to say? Do you remember seeing the banner
Yes.
in the video? Okay. And
You're referring to the back of the pop-up tent?
correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
What do you
Is
remember
it
about the
opaque?
banner?
Is it
Well, it's kind of like
transparent?
No, you
a
can't see
banner.
through it. It's white, and then you cannot see through it, no.
And
Kind of
how much of
bannerish.
the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
Okay. And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Okay. Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
Okay. At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the...
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
Okay. And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
Okay. And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked
Thank you for the
about
471 of you
tips,
currently watching.
including threats
I love you.
to
If
Mr.
you wouldn't
Kirk,
mind giving us a
I think
like,
before the
it
event.
would be appreciated.
And did you follow up on
As
those
we
tips?
give to you excellent courtroom audio and
After tips have been through
fantastic
a process and been analyzed
commentary.
and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement. So
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes.
Okay. So identities of possible shooters.
Correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was the Washington County Sheriff's Office.
Yes.
Okay. You understood that he turned him. Well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the Low-C building, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position.
Correct.
And then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you, Your Honor.
We have just a minute to meet with
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
All right, guys. Well, we learned more about the investigation steps, which are kind of things you would have been able to infer without being told, except they were actually competent. So that's nice, right? We have a lead investigator who, by all appearances, is actually competent and reasonable at his job and took reasonable steps, along with the police department as a whole, who appeared to take reasonable steps, such steps including such things as not going to the autopsy, inventing this concept called chain of custody. I've never heard of this thing before, chain of custody. It appears to be a brand new invention. Maybe it will catch on. as evidence was sent from the medical examiner back to the police department. Interviews with people, including someone with a Ring camera, trying to determine that if it was authentic. Tips that were coming in and followed up on. The lead investigator himself taking some steps personally, but, not doing everything himself because he's just one guy. And his overall mission was to, secure the investigation as a whole. So while he took some steps personally, mostly not. It was other people doing things. He didn't have to touch every single part of it personally, like he was a solo operator. He actually relied on other people to do their job in a competent way. And early on in the investigation, there were some doubts about things like the timeline. There was a little bit of vagueness about exactly what happened in what order. And there were some police officers who put together some timelines. And then later, on the 14th, 3 days after the event, or 4 days after the event, he put together his own timeline based on the accumulated reports of the various officers, plus his own review of some of the primary evidence, such as the videos. And together from that, cobbled together his own timeline, which may or may not be perfect, but it was an improvement on what was known at that time. Also, he didn't initially know who the suspect was. And he doesn't really know exactly how he got to the police station and doesn't really care very much. And he was investigating all the leads because he didn't just immediately come to a conclusion. He didn't just immediately say, wow, we've got our guy, case closed. The investigation continued past Mr. Robinson showing up at the police station. Further steps were taken to investigate more and look into things. Maybe Mr. Robinson's falsely confessing like the other guy. Maybe we should keep looking. See if we can determine if Mr. Robinson was the guy. Investigate other leads as one does. Wow. Amazing. Great. So, and also the banner might block people's views. And there may or may not have been anyone behind the banner at the time, which only matters in so much as we might want to charge the shooter with potential reckless endangerment of people beyond Mr. Kirk, right? Because the bullet obviously posed a reckless risk to other people. So to the extent we want to charge him with like reckless endangerment, it might matter if we're trying to pursue those additional charges, but doesn't really matter very much to the core of the case. I'm not sure whether or not they're pursuing any charges beyond the murder. But, it doesn't also really matter, of course, what the shooter was shooting at from first legal principles, because intent follows the bullet, don't you know? So even assuming that the shooter was trying to hit someone else other than Mr. Kirk, it doesn't really matter very much because he killed Mr. Kirk. So that's kind of the end of that discussion. He, with intent and purpose, pulled the trigger. Mr. Kirk died as a result. Therefore, he is liable as a result of the death, regardless of whatever his subjective intent might have been at the time. So there's all that. Intent will matter for the death penalty? Maybe, but that's up to the jury to decide how much they care or not. But yes, it may matter subjectively to the jury or not what he was trying to do. It doesn't matter as to liability, but might it matter to a jury as they decide whether to impose the death penalty? I guess, maybe. During the jury can consider a wider range of factors as they consider what a punishment is appropriate. But as to liability, not so much, no. Yeah, it would be hard to prove to a reasonable jury he was aiming at something else. Yes, that will be very difficult. And of course, at that point, it's no longer proof beyond a reasonable doubt because it's only guilty until proven, and it's only innocent until proven guilty. Once he's found guilty by the jury, he has been found guilty. So the standard at the death penalty, at the penalty phase, is no longer proof beyond a reasonable doubt. So they don't need to be absolutely sure. They just need to believe it basically is more likely than not. So, yeah. Or it might be slightly higher in Utah specifically, but it's not beyond a reasonable doubt. So whatever. Does Utah actually kill people? From time to time, yes. Yeah, there's a real chance of him being put to death. Eventually, someday. But of course, for me, my interest in this is less in legal elements and in things like motive, right? Why did he do it? You know, whether he had any assistance is also interesting in any sense, accessory or otherwise. Conspirator would be interesting. Accessory, possible, whether or not anyone assisted him in any way. Whether or not there's something bigger than that. Whether or not he was, influenced by Discord or Twitter or other things like that might have informed his desires. Those are actually interesting aspects. Yeah, we've not heard anything on forensics yet. We've not heard anything as it relates to experts on ballistics. So whether or not the amount of damage is consistent with the rifle is hard to say. There are scenarios in which it seems consistent to me, but it relies on information that we don't have. So, we don't have enough information. During the trial itself, I'm sure there will be competing experts on the questions of ballistics and what a rifle round would or would not do in this scenario, depending on a whole host of factors. So we won't get that information today because we don't need it, but it will come up at trial, I'm quite sure. I understand the skepticism, though. But it appears that the bullet passed through without really dumping a lot of its energy into the neck. So it appears to have mostly just severed the blood arteries without really dumping the energy into the body. So, but it's unclear. Some people don't think that I don't know even what the state has said about the bullet in terms of whether it passed through Kirk or not. I don't even know what their position on the issue is. So if it was stopped by Kirk, that would be one thing. If it passed through, that would be another thing. I don't know the answer to that question. They mentioned finding bullet fragments during the autopsy, however, which is suggestive that at least portions of the bullet, stayed in Mr. Kirk. So it didn't appear to go through completely intact because they mentioned fragments being recovered during the autopsy. So at least portions so it appears to have fragmented. But whether that means all the bullet was left in the body or not, I don't know. Yeah. So we'll learn more about this during the trial. We'll learn more about how many fragments there were. We'll learn more about where they were found. We'll hear extensive medical testimony. I have no doubt that the medical examiner is going to be on the stand for quite some time during the trial, talking about exactly what was discovered relating to this, and there will be experts beyond that relating to ballistics. I'm quite sure. For both sides. Yeah, a hollow point round for a rifle is very unusual. Yeah. So typically Full Metal Jacket is more typical in a hunting round. But, you know, we don't know what kind of ammo it was, so it's not worth speculating about. You think it hit the spinal cord and fragmented? Maybe. If it hit the spinal cord, I'm sure that meant death was instantaneous. But the amount of blood loss was pretty instantaneous anyway. Do I think it's possible the defense doesn't put on a defense? Not really. This defense lawyer doesn't seem like the kind. I mean, the only thing that's possible is that they concede liability and dump everything into the sentencing phase, right? He basically confessed to it, right? So the only thing that is possible is that the defense lawyer, along with the client, because the client obviously has to plead, right? So it's up to the client, unfortunately, in the end. But the only thing that makes sense, and you do see it in death penalty cases from time to time, is that they concede on liability, that is to plead guilty, in order to dump all their case into the sentencing to gain some credibility with the jury, right? It's like, because if they fight on liability, it'd be like, we didn't do it. It's really hard for the defense to turn around and be like, okay, well, given he did it, here's why you should show mercy on him. That's a tough road to hoe. So it's very reasonable the defense might, if the client is willing, plead guilty and dump their entire case into sentencing. It's been known to happen in death penalty cases. And given the fact that he apparently confessed and there's overwhelming evidence, it's a very real possibility. So if he pleads guilty, it won't surprise me. It will be a naked plea of guilty. It will be a plea of guilty without any conditions from the states, I'm sure. But that is a non-zero chance of happening. And this could be in service of that goal. So if you're looking for reasons for the defense to do this, it could be to do a come to Jesus meeting, not because the government's offering a plea deal, but because his lawyers really want him to plead guilty to save their ammunition, pun intended, for the sentencing phase. So that could be what's going on here, potentially. Or it could just be that they like to hear the sound of their own voice and are just self-promoting because they make a point of announcing their name every single time. So they're just trying to get some media recognition out of this for their future whatever. Yeah, this could be a sales pitch for a plea. This could be the defense lawyers trying to do a sales pitch to their own client. Look at the truth. Plead guilty. It's your only hope, as thin as it is. Could be. Could be. Given the confession, and he told his own parents about it, right? And then he went to the police station and he probably said some things on a tape. There's probably tape of him at the police station saying all kinds of things that will be very, very incriminating, I'm sure. So given the fact that he confessed, him pleading guilty is a very plausible option. Could be. Yeah. You're a criminal defense attorney in Illinois? Excellent. I'm glad that you're enjoying my coverage as I try to explain various strategic reasons that this could be going on, because this preliminary hearings are very unusual. They're not usually done. Half the time, there's a grand jury, so that kind of moots the issue. And the other half of the time, the defense lawyers waive it because it's kind of pointless. also it can reveal things about their defense strategy. So there's some risk to the defense. Maybe they feel like that risk is minimal here because their strategy is somewhat obvious. So maybe they feel like they're not really giving up very much, and they're kind of hoping. There's a couple things they could be trying to do. They could be trying to somehow extract some more specific defense strategy. So they're hoping that somehow one of the witnesses will say something that will somehow give them a more specific direction to move in, as unlikely as that is. More probable, they could be trying to induce the state into some kind of error, right? They could be trying to hope that the state is going to make some kind of mistake that is going to induce an error that is somehow going to undo the conviction way in the future. That's very unlikely. Preliminary hearings are subject to such looser rules than trials. It's very unlikely that there would be such a massive error. And the judge has not made anything that could even become close to those kinds of mistakes yet. So that ain't happening, but maybe that was their hope. Another reason is because they're doing it as a come to Jesus meeting for the client. Please plead guilty without any plea deal. Just plead guilty. And let's dump our entire case into sentencing and pray to whatever God we believe in. It could just be a marketing tool by the defense. Look at me, here's my name, please call me. So it could just be a marketing tool. Yeah. Other than that, I'm not sure what it could be. I didn't say it was as a marketing tool, I'm not sure how good it is, but that's not for me to judge. I suppose it's for her potential clients to judge. If anyone who is a competent criminal defense attorney can think of any other reasons this preliminary hearing is happening, I'd be interested. I mean, it's obviously not to get evidence. They already have all the evidence from discovery. So it's not that. So what else is it? I've come up with 4 different ideas of what it could be. Anyone else got any ideas? Yeah, you think they're fishing for something to appeal? That's very plausible. Very unlikely out of a preliminary hearing, though. Preliminary hearings are so loosey-goosey by comparison to trials. It's very hard, and any mistake that could happen could be cured.
We left off with Agent Hall was excused, and we are proceeding. Mr. McBride.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objection.
No, there's going to be an objection from the defense. You don't say.
It could be a lengthy call.
All right. Let me just... do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Englehart from Turning Point USA.
All right.
And again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102 There are also, there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102, because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak, as you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think, I am not trying to conceal from anybody in the courtroom or the public, of course, our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance, and if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the third person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk, and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the second paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence. and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Englehart's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Englehart says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Englehart's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Englehart's opinions about a branch of Christianity, his opinions about a portion of the Bible.
That feels pretty irrelevant.
He quotes the Bible.
Thank you, Max Bang, for the $5.
And he talks
Appreciate
about
it.
Mr. Kirk's religious beliefs.
That feels
And I could
pretty
go into
irrelevant.
more detail, but the court has the exhibit in front of it itself.
Yeah, that feels a lot irrelevant.
So none of this is relevant.
Yeah, I'm not feeling
If
it.
the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document.
Yes. He means it in a legal sense. I understand.
There are, with respect to certain counts, what Utah code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7.
This, as I understand it, this is an affidavit from Turning Point USA describing Charlie Kirk's beliefs, not Tyler Robinson's beliefs. So what Charlie Kirk believes is irrelevant. What might be relevant is Tyler Robinson's beliefs about what Charlie Kirk believed, but his actual beliefs are not relevant. You know, what Charlie Kirk believed in his head doesn't really matter very much. What Tyler Robinson believed in his head, much more relevant. But this affidavit doesn't seem to be speaking to that. So it's not relevant as far as I can understand.
And may I step away just to get my laptop?
You may.
Thank you.
If I understood correctly.
And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression.
But he doesn't know what that
I'm going to
is.
focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K.
Yeah.
That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M.
Okay.
So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K.
Yeah, but how does Turning Point USA know that?
The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values.
No.
That he believes in, that he believes Mr. Kirk believed in.
Yeah, this is nonsense. If this is an accurate description of what this is nonsense. If I'm understanding correctly, this is an affidavit from Mr. Engelhardt, who I believe is the head of Turning Point USA, or it's a letter from it's a letter from Turning Point USA describing what Turning Point USA believes and describing what Charlie Kirk believes. But that doesn't really matter, because what matters is what Mr. Robinson believed, right? He can't be targeting him for those reasons unless, first of all, he's aware of it, and second of all, that's the reason he's doing it. So what Kirk's beliefs are doesn't really matter, right? It doesn't really matter what Kirk's beliefs are in fact. It doesn't really matter what Turning Points USA's beliefs are in fact, right? What they actually believe isn't relevant. What matters is what Robinson believed about it, right? Robinson's perception, because it goes to his motive, right? You can't shoot people because of these reasons. If you shoot people because of these reasons, it's extra bad. You can't do it because of that. It's extra bad if you do it because of that. But what matters is Robinson's belief about it, right? If Robinson believed it and was doing it for that, not what Turning Point beliefs or Charlie Kirk's beliefs are in fact. So this affidavit is answering entirely the wrong questions. And so if this is accurate, it's wholly irrelevant and should not be admitted.
And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind.
Yeah, that's what matters.
Not
Robinson's
what is in
state of
Mr.
mind.
Kirk's views or
Correct.
deeply held beliefs, sincere religious beliefs.
Yeah. What matters is Robinson's state of mind,
The evidence
not
that
Kirk's.
the state needs to present is not what Mr. Kirk believed or said,
100%.
or what TPUSA stood for. It's what was in Mr. Robinson's head.
Yep.
If anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information.
I agree, 100%.
So
why
TPUSA?
So is that what we're doing? So is that how we're dividing defense lawyers up? When we want to make bullshit, meaningless objections, the woman lawyer speaks. When we actually want to make real objections that we actually care about, the male defense lawyer speaks. Is that how we've decided to do? Okay, here's how we're dividing responsibility. Your team bullshit, I'm team actually stuff that matters. Is that how we've decided to do, how we've decided to allocate responsibility? Okay, cool. All right, fair enough. Moving on.
Exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence.
I agree.
There's a
Sounds like
second
bullshit.
level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9.
Oh,
and so
no.
I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible,
oh dear,
in order to prove this enhancement, because I can't see where else it fits into this case.
Yep.
I think, if I may, the answer would be no, it's not relevant.
I agree. Yeah, it is not relevant. I don't know how to explain this, but like, yeah, it doesn't matter. It doesn't matter what the Bible says. It doesn't matter what Kirk believed. It doesn't matter what Turning Point USA believed. What matters is what Robinson believed. His motive, his state of mind. Was he doing it because he believed Kirk to be an atheist? Who the hell knows? That wouldn't be cool either. Was he doing it because he believed Kirk to be a blatant liberal, Democrat, pro-abortion, socialist? I don't know, but if that's what he thought, that would matter. Not what Kirk actually thought. What matters is Robinson's state of mind, not Kirk's. Yeah.
So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here in this proceeding what the book of Matthew says.
Yep.
It doesn't matter what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt,
It
who
doesn't.
I've never met.
It doesn't matter what he thinks. He's the lawyer's
Matthew
right.
means.
And yeah, that is also not what
Or how
matters.
one reconciles the book of Matthew as he sees it with other views on
Yeah.
the topics that are there. I mean, I want to be careful and
Why the state wants to offer this piece of evidence is beyond me. This is a massive mistake from the state. Why would the state want to offer this? Why would the state want to offer this exhibit? This is just begging for reversible error, right? You want to bring in what the Bible actually says and have a debate by the court about what the Bible actually says and means? Are you out of your mind? What is the state doing? Why would they do this? This is insane. Is the state competent? What are you doing? You shouldn't be anywhere near this.
not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact.
It is not.
That's your honor.
It's very not. It's also not helpful to the jury.
That helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court.
This is horrible.
Because the court has to decide whether there is evidence of the targeting enhancement in the way I think I've structured.
If I'm the judge right about now, I want to take the prosecution out back and beat the shit out of them. Are you fucking insane? What are you doing? Have you lost your mind?
Structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion.
It's not.
There are two aspects of Rule 403, one of which I'm prepared to talk about publicly and one of which I think is appropriately discussed at sidebar because it does get into undue prejudice. The 403 here is that receiving this document into evidence is
mistake. It's a mistake.
Confusion. It's going to create chaos.
It's a horrible, horrible
not by the trial
mistake.
Fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Englehart's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion.
This is disaster fuel.
The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Englehart for some specific evidentiary purpose that I'm missing.
I'm missing it too.
And we can,
it's not just
engage in that, but
I'm having a hard time even imagining hypothetically how that would happen. How that would happen.
An expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak.
This is
Turning to the
insane.
state.
This is insane. The prosecution
So,
is out of
just
its
to
mind.
Give an overview. What I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you, Mr. McBride.
If he doesn't say, never mind, my bad, he's out of his mind.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive.
No, it's
which
not.
is not an element of the offense, but nonetheless is powerful evidence.
It's not that either.
Persuasive evidence. And 2, it is relevant to the victim targeting enhancement.
No, it's
Which
not.
has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's
I'm
business
going to
was.
lose my shit.
And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality,
Absolutely
marriage,
not.
gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection.
This is
Make
insane.
sure that you are heard as well.
This is insane.
Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that
I
exhibit?
got it. I know enough.
That's
I
what I'm
figured it
putting in
out.
front of
I
your
figured it
honors,
out 5 minutes
explaining
ago.
This is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Your Honor is not a jury. Your Honor can look at the exhibit
This
and
is stupid.
determine for itself whether
This
it's
is absolutely
relevant,
insane.
whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has 2 roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to infuse the issues in this case and create fair trial risks for Mr. Robinson.
All right. Thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding, but I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor, and I think my job and my duty to my client, which is the
I
state
know
of
what the
Utah,
exhibit says.
and to
I know
their
exactly what the
right to
exhibit
fairness
says.
requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll
I know
submit
what the
with that.
exhibit says.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically. He mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it.
No.
So what I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly, saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride in regards to your response, the rebuttal to the argument by Mr. Novak. What is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right. Well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty, I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about?
I know what you're talking about.
There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard before you do.
All right, I'll hear from you as well. If you would like to come forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial.
This is super dumb, by the way.
Which
His entire argument is super dumb.
Even is a trial.
This obviously should not be admitted.
We've cited the
I
court
can't believe we're having an argument about
numerous
this.
cases on this.
The answer is
I don't have the brief
obviously
in front of
no.
me, and the docket is huge, and
Uncivil
I can find
math.
it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, a closed session or a sidebar or however, you have also done it in chambers, I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right. Thank you. Anything further, Mr. McBride?
Just a note, I have not made my full argument on admissibility, that's all.
All right. All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder, and whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information, going to the very beginning, whether this is relevant. And as noted by counsel, looking to count one, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count one, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count two, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you.
Okay. I just want to summarize the issues for those of you who are late to the party, because some of you are late and you want to know what's going on. So I'm going to describe what's going on and tell you what they're arguing over and why it's really, really dumb. Okay? There is an affidavit from somebody at Turning Point USA. I presume it is the new CEO. Okay? You can hear me, right? I'm not muted anymore. Am I still muted? It looks like my audio is working. Okay, we're good. Great. Okay, we're good. Let's do this again. Okay, great. Let me summarize the issues for those of you who are late, okay? And I'm going to do this so it can be done as an edited video for later, okay? So at today's hearing, the government wishes to offer an affidavit from somebody at Turning Point USA. I presume that this person is the new CEO of Turning Point USA or co-CEO, but it doesn't really matter who it is. All you really need to know for the purposes of our discussion is it's someone at Turning Point USA who believes they can speak with authority on two things: what Turning Point USA believes and what Charlie Kirk believed. So this affidavit goes through these two things: what Turning Point USA believes and what Charlie Kirk believed, and what he did and what Turning Point USA does, including, for example, that he goes to colleges and engages in political and or religious discussions / debates with people. And this is what Turning Point USA believes, and this is what Charlie Kirk believes. Okay, great. So that's what the affidavit says. It has this statements. The government apparently wishes to use this information for an enhancement for the murder, because certain murders are considered more bad than other kinds of murders, which is not atypical. Different states define this differently for different degrees of murder. And so among the many things that makes murder particularly bad in the view of Utah is if you target someone because of their political views or because of their religious views, among other things. These are 2 out of 9 things the state of Utah particularly does not like. Okay? So the state wishes to offer this affidavit as a sentencing enhancement to show that they have this criteria. They want to show it to be able to charge this murder, that this is a foundational thing to be able to meet the statute that requires this showing to charge this murder with this enhancement. This affidavit is not suitable for that purpose, because the question is not what Turning Point USA believed, nor is it what Charlie Kirk believed. The question is, what did Tyler Robinson believe about Charlie Kirk and or Turning Point USA, and or whether or not that informed the reason that he shot Charlie Kirk, because it's illegal to shoot someone because of these reasons. So what matters is not what is true in fact. It doesn't matter what Turning Point's beliefs religiously or politically are in fact. It doesn't matter what Charlie Kirk's beliefs religiously or politically are in fact. What matters is Tyler Robinson's perceptions, and whether or not those perceptions were the basis of his actions, going to his mental state and his reasons and his motive, right? So Turning Point USA, and this guy at Turning Point USA can't speak to that question, because he's not claiming that he knows Tyler Robinson. He's not claiming that he has a particular understanding of Tyler Robinson. He's claiming that he has particular understandings of Turning Point USA and particular understandings of Charlie Kirk, but that isn't what's relevant. What's relevant is Tyler Robinson's subjective mental state. Did he do it for these reasons? Even if mistaken, if he believed them to be true, that is sufficient. So just to take an example to just prove the point, although it would be somewhat absurd if Tyler Robinson, in his heart of hearts, subjectively, genuinely believed that Charlie Kirk was a dyed-in-the-wool, progressive, left-leaning Democrat who is in favor of abortion, is pro-choice to the point that he wants government funding of it, and believes that all abortions should be free for everyone, everywhere. And Tyler Robinson killed Charlie Kirk because he disagreed with that viewpoint, and that was his reason. That would be a valid sentencing enhancement, because although his belief is ridiculous objectively, if subjectively that's what he thought, you can't kill people for those reasons. You can't kill people because they are dyed-in-the-wool, progressive Democrats who are pro-choice and believe in the government's funding of all the abortions and that should be available on demand at any point during birth. You can't kill people for those reasons. So although Charlie Kirk didn't believe any of those things, of course he didn't, that isn't my point. If that's what Tyler Robinson believed, that is the point. So it doesn't matter what's true in fact, it matters what he believed and whether or not he was killing him for those reasons, as opposed to other reasons. I don't know what those would be, because it all goes to his mental state. Did he do it because he believed that Cthulhu himself spoke to him and said that you should kill this guy because I demand a sacrifice for my octopus-like God that I am? Is that why he did it? Who knows? Who knows? But you know who doesn't know? You know who doesn't know? Whoever this guy is from Turning Point USA. He doesn't have the first clue. He has no clues as to this subject. So his affidavit is irrelevant, is prejudicial, and apparently includes Bible verses. Like, we're going to start introducing that as evidence now? Unless, the murder weapon had Bible verses, scrawled on it, or the ammunition did or something, right? Then it doesn't reflect the shooter's mental state. So I don't know, nor do I really care for the purposes of this exercise, what Turning Point USA nor Charlie Kirk believed about the Bible or about the book of Matthew or about whatever chapter they're quoting from, or really anything else. The only thing I care about is what was going through Tyler Robinson's head and his motives. So this affidavit is irrelevant because it doesn't speak to anything involving that question. It can't possibly be used to justify the enhancement because it doesn't go to his belief. it is wildly prejudicial because it goes to like what is true about religion. Holy God, right? You want courts to start opining about what is or is not true about religion. That seems like an invitation to disaster. And so this is just calling all the alarm bells in my head. Every single alarm bell in my head is just going danger, 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 danger. This affidavit is irrelevant and so prejudicial as to comprise error. So I can't believe we're having this discussion. I can't believe we're having this argument. I can't believe the government apparently wants to introduce this. The government is absolutely out of its mind, certifiably out of its mind to want to offer this exhibit. If they had an affidavit from somebody who can testify as to Tyler Robinson's beliefs, what Tyler Robinson thought, maybe his views about what Matthew said, then, maybe. But it's not that. It's what Charlie Kirk or Turning Point USA believed. And I have to say, who cares? No one cares. It's dumb and stupid. And unbelievably prejudicial. Unbelievably. Great. Now they're going to argue about this for a while.
In terms of the evidence that the state is proffering to prove a very narrow point, and it actually doesn't get to that point, which is what was Mr. Robinson's state of mind.
Right.
It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue.
Preach it, baby. Preach it.
That would even make a piece of this relevant.
Right.
So
correct.
I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to
I have a question. Is the state certifiably insane?
Religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
Okay. All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written.
Who cares if they intersect? So it's both things at once. So what? You can't do it for either reason. If it's simultaneously both, then it's just bad for both reasons at the same time. What are we talking about? Who cares about the intersection? It doesn't matter.
The state,
as long as it's one or the other. If it's simultaneously both, so much the better. Who cares?
Which was, let's just say, hostile to Mr. Kirk's political expression.
This is stupid.
And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect.
Does it matter?
I mean, if
who cares?
If the court needs to resolve that issue, then the court also needs to resolve the question of Which religious philosophy are we talking about?
Well,
The
Mr.
one
Novak,
that-
I bring that up because
the
you
one
mentioned it,
that
and you said
Tyler
you cited
Robinson
directly to the enhancement. You
believed,
said
Charlie
political
Kirk
expression, and then you
believed.
went to
That's
the
the
Bible
one.
itself, and so it appeared to the court that you put it into place. So I just wanted to get a little bit of guidance from your position, and so that's the reason for the
No,
question.
I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question.
See,
Any
it
question
does.
that the court
Yeah,
asks
John, you're
is
asking
a
the wrong
that-
question. It doesn't. You're asking the wrong question. The question isn't whether Charlie Kirk was a Christian. In fact, the question is whether Tyler Robinson believed it and killed him because of that reason. And how would you know that? I don't know. You have to find evidence as to his Tyler Robinson's subjective mental state. I don't know if there is any such evidence. I do know that it doesn't come from Turning Point USA. I'm quite sure about that. Among the many people it might come from would potentially include, among others, his boyfriend, his parents, what he told the police, any manifesto he wrote, blah, 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 blah. I don't know what evidence you have of a subjective mental state. I don't know. But I guarantee you it doesn't come from TPUSA. I'm quite sure about that. I hate it. I hate everything.
And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
This argument is so stupid.
All right, anything
I
further
can't
before the
believe
court
we're
makes its
having it.
ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
No, it doesn't. It absolutely does not.
All right. And,
If it
and
did,
making
that'd
this
be great, but it
determination
doesn't.
Whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated.
He's going to admit it, isn't he?
Is this relevant, what is before me?
He's going to admit it, isn't
without
he?
indicating my decision on probable cause, because I am not at that point. I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant
No,
as
it's
it
not.
relates to the victim targeting enhancement.
Unfucking believable.
As it relates
That's
to
a
Charlie
mistake.
Kirk's political expression.
It's a bad
and the court
mistake.
recognizes the argument
It's a
made by
horrible
defense,
mistake.
in regards to state of mind. It is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again, and the request for it to be fully.
If a senior judge doesn't find this judge and beat him to death, I swear, someone's got to talk to this judge and be like, no, absolutely not.
Proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All right.
That's a massive mistake. That is just a massive mistake. That's wrong. That is a massive mistake. I tell you what, if that thing shows up at trial, woof. Yeah, that is a massive mistake. He might be able to get away with it for the preliminary hearing, but wow. Because it's probable cause determination, it's so low, but like wow. But if that shows up in the actual trial, woof. So if the defense was trying to induce the government into making an error, they're making one, man. They're making one. They are way off. This is an error, and this is a major error, because you're injecting religion from Charlie Kirk's point of view into this. This is a massive mistake. If this goes to trial and this winds up in front of a jury, just start writing your appeals, man. Just start writing your appeals. And to be honest, it's so prejudicial at this point that like I would throw it into an appellate brief someday. I wouldn't expect this to work just because of this, but because the standards are so low. But wow, just wow. Yeah, I can't believe the judge made that mistake. That's bad. That's a bad mistake. Yeah, so much that it could require a new trial. Yep. Yes. Yeah, if this winds up in front of the jury, this is the kind of mistake that an appeal could be based off of. This is a big deal. This is a big deal mistake. Harmless error. Oof. I don't know, man. I don't know. This could be so prejudicial. A harmless error analysis, man. I don't know, man. I'm telling you. You're injecting religion into this. I mean, of ways to get to harmful error. Let's start quoting provisions of the Bible, not because they're what the defendant believed, but because it's what the victim believed. And this is what the victim believed, and he believed in these principles, and so he's a good Christian man. We find him guilty and give him the death penalty. You think the Court of Appeals is going to say that's a harmless error? I don't know, ma'am. I don't know. I'm doing the harmless error analysis in my head as we speak, and I'm like, yeah. Harmless error analysis is the correct analysis. It's just on this occasion, I don't know about that one. I don't know, ma'am. Feeling kind of harmful. You know, I can, maybe you don't have any evidence that he did it because of his, I don't know what other evidence the government has. The fact they're doing this suggests the government doesn't have any other evidence. I mean, that's the suggestion. Because is this really the best you've got? Really? I mean, this is suggestive that the government does not have any evidence going to Tyler Robinson's subjective mental state. It is suggestive that during his interviews and his confessions and his discussions with his boyfriend or whatever, it is suggestive that Tyler Robinson did not reveal he was doing it because Charlie Kirk's politics or Charlie Kirk's religious views. I don't know that to be true. It's just like, if I had that, that would be what I would be presenting, right? And I can do hearsay. I don't need the witnesses right now because I can do hearsay. So if I had a statement from the boyfriend or a statement from the parents or whatever being like, yes, our son told us, my boyfriend told me that he was doing it because Charlie Kirk is an evil fascist / deep communist / wants to ban abortion / loves abortion / whatever. Like if I had those statements, those would be the statements I'd be introducing and be your honor. I've got this. I know it's hearsay, but I've got the statements, showing this evidence. That's my prima facie. I'm good, right? I'm good. That's all I need. Instead, what we've got is this statement from Turning Point USA. Like they have any idea what's going on in Tyler Robinson's head. Do they have any idea what's going on in Tyler Robinson's head? They do not. They have no clue. So it is suggestive the state doesn't have anything else. And therefore, it is suggestive there's problems out the ass on this. It is suggestive that they cannot make their enhancement. And the enhancement is the thing that's getting them to the death penalty. So it is suggestive the state does not have it when it comes to the evidence necessary for the death penalty. Because if they did, surely they'd be presenting it instead of this garbage. So the conclusion I can draw from this is that the state cannot make its burden as to the enhancements necessary for the death penalty. And they're about to prejudice the entire case to try to get to where they want to be. If they bring this up in liability phase, it taints the conviction. If they bring it up in the sentencing phase, I suppose it doesn't taint anything because there's just not the enhancement. And so the sentence to death will be thrown out by the Court of Appeals. It should be. Yeah. So it's suggestive they cannot make their death penalty burden. That's what's suggestive of. If I had evidence, a statement to the boyfriend, a statement to the parents, manifestos, emails, text messages, whatever, I'd be presenting that, not this. This is some garbage. In my opinion, life or the death penalty. Well, at the moment, it seems like they may not have the factual predicate for the death penalty. Yeah, so at the moment, I question deeply if they have the factual predicate necessary for the death penalty. So there's that. Yeah, this is a very strange way to go about it. I don't know why they're doing it this way. I don't understand. It seems like a bad pool. It seems like bad pool. Right now, I know that there are some far right legal commentators who are like really happy about this because they have their head stuck up their ass. I just know that there's some hard right. There's people so far on the right. They're like so like pro-religion or pro-whatever, right? They're like, well, thank God that Charlie's beliefs are being presented. This is a good day for America. We no longer have to shy away from religion. And I'm like, you're a bunch of fucking morons. You're idiots. What are you doing? And then when the Court of Appeals inevitably turns them over someday, it'll be those damn left-leaning judges on the Utah Court of Appeals. Those far left progressives on the Utah Court of Appeals. overturning this death penalty conviction. How dare they? Yep. Yep, that's great. Fantastic. It's fantastic. So the state was doing great. Yeah, the state is now clenching defeat from the jaws of victory. They're clenching defeat from the jaws of victory. They're doing a Hillary Clinton. Lol. They had it in the bag. All they had to do was not fuck up completely. And they somehow couldn't manage that. Wouldn't what was written on the bullets be evidence? It sure would. Maybe they should be talking about that instead. That'd be great. Maybe that would be some good evidence. What was written? Yeah, what was written on the bullets? Maybe that would be some good evidence to bring in right about now. That might be helpful. Sure. Yep. Well, Uncivil needs lunch. Should we take a break? I think we should take a break. Uncivil needs lunch, and Uncivil needs to, like, you know, stop yelling at things. The court has given me 45 minutes, and I'm going to get some lunch. I have some nice gumbo sitting in my fridge that I'm going to heat up and eat, and I'm looking forward to it. But we'll be back in 45 minutes to see how much more stupid the government can do today. We're on day 2. It only took till day 2 for the government to do stupid. Great. We'll see how much more stupid it's going to get after lunch. Until then, I've been Uncivil Law. Let me go ahead and just schedule a thing for later, and then, you know, I'll redirect you there. I might call Recovery Addict and yell at him for a while. This is at 2:45, right? 1:45 their time, 2:45 my time. Okay. All right, I'm sending you over to this afternoon stream. Don't forget to like, comment, subscribe, and engage with all that to help promote the video. I'll see you guys in about 45 minutes or so. Have some lunch. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.